Recording.
Good afternoon, everyone, and welcome to the AFME member briefing on anti-money laundering. Is a new regulatory framework needed? My name is Will Dennis, and I'm the head of compliance at AFME, which includes AML. I'd like to introduce our speakers today. We have a stellar panel: John Clarke, MLRO at Standard Advisory London, formerly holding down senior AML posts at Bank of New York Mellon and at JP Asset Management. And John is the co-chair of the AFME Financial Crime Working Group. He is here with Rajiv Kapur, who is an executive director in the Risk and Policy Group of Financial Crime Compliance at Goldman Sachs, member of the editorial panel of the Joint Money Laundering Steering Group, and the other co-chair of the AFME Financial Crime Working Group. And sitting in between these two practitioners is a lawyer, Susannah, Cogman, partner at the international law firm of Herbert Freehills. Susannah, very well respected in the space, and spends her time advising clients in the whole range of financial crime, including AML, but also sanctions, ABC, and fraud. And the fourth member is my colleague Adam Willman, who is director looking after financial crime and tax policy here at AFME, and a former lawyer at Norton Rose. In the main portion of this briefing, John, Rajiv, and Susannah will probe some of the areas that Adam is going to highlight in more detail, as well as discussing other key AML issues. We'll follow that with a Q&A. I would encourage you all to submit questions for the Q&A, which you can do at any time during the briefing by clicking on the Q&A icon on the right-hand side of your screen and typing in your question. And you don't want to hear any more from me, so I'm going to hand over to Adam to introduce the subject.
Thanks, Will. Good afternoon. My name is Adam Willman, and as Will said, I'm Director of Financial Crime and Tax Policy at AFME. This is a particularly busy period for AML policy. In September, the European Commission published its proposals to strengthen the AML supervisory responsibilities of the EBA for the EU. The two principal objectives are to harmonise the national AML regimes which exist across all member states, and secondly, to integrate more effectively AML with prudential supervision. The proposals for the EBA are very ambitious. In summary, the European Commission wants to concentrate the EU-level AML expertise and resource into one agency. It wants to turn the EBA into an AML data hub, a central repository for the filing of SARs across the EU. And it wants to strengthen the EBA's investigatory and enforcement powers and give the EBA responsibility for producing guidance and standards. This could be a very significant step forward in the fight against financial crime. However, the EBA will require significant resourcing and investment, and it could take several years to implement. The danger is that it could end up introducing another costly layer of bureaucracy without tackling effectively money laundering. AFME has been very active from an advocacy perspective. We've prepared a detailed position paper, which has been shared widely. We've held meetings with the European Commission and the EBA, and we've been invited to participate in a European Commission roundtable in Brussels on the 23rd of November, alongside other financial services sector representatives. In terms of next steps, the proposals have been introduced as part of the draft regulation reviewing the role of the ESAs, and they are expected to be agreed in the first half of 2019. The European finance ministers are expected to adopt an AML action plan in early December, which, amongst other things, we understand will set out further, more detailed improvements in the integration of AML and prudential supervision. And I think just in the last week or so, the ESAs published draft guidelines to improve the cooperation between national AML supervisors, and that's open for consultation until February 2019. Clearly, there's a huge amount going on in this space, and it's a very active and exciting time, and very closely involved in the advocacy on this. Just a quick word about some other key AML work streams which AFME has been closely involved in. The new Commission proposals come very soon after the implementation of the 4MLD, which of course came into force in June 2017, and we have the forthcoming implementation of the 5AMLD, which comes into force in January 2020. At the end of October, the FATF published its risk-based approach guidance for the securities sector, an important tool against money laundering, and AFME has been a member of the drafting group over the past year. AFME are also members of the Joint Money Laundering Steering Group Board and Editorial Panel, which continues to produce key guidance for financial services. AFME is in the midst of a review of Chapter 20 concerning brokerage services to funds, having led a successful review in 2017 of Chapter 18 of the guidance for the wholesale markets. The UK's FCA has initiated a thematic review of money laundering risk in the capital markets, having determined that the UK capital markets are high risk in the 2017 UK National Risk Assessment, and we are committed to educating the FCA about how the capital markets operate and focusing their attention on the areas of highest risk. We're also members of the Joint Money Laundering Intelligence Task Force, the GIMLIT Money Laundering Through Markets Expert Working Group, an excellent public-private collaboration which aims at identifying typologies or examples of money laundering cases which can be converted into industry bulletins and alerts. And finally, the FCA, just a few hours ago, I believe, published the results of its first financial crime data return, providing feedback from a survey on what the industry is doing to tackle financial crime. That's just a flavour of some of the things that AFME has been closely involved in recently, and I hope paints a little background to the discussion we're about to have. Back to you, Will.
Thank you, Adam. Maybe we could just go back one and ask the panel, why is this all topical now? Why is AML suddenly in the news across Europe?
I think in the UK, well, there's a couple of reasons, but I'll probably highlight particularly the fact we've just been going through the FATF mutual evaluation review process. Now, I think according to press reports, the expectation is that the UK will have done reasonably well in that process, but that involves a review both of the technical implementation of the FATF standards and also the effectiveness of a country's implementation. So looking at matters such as sort of enforcement, intelligence sharing, how SARS are dealt with, etc. So I think the UK, for very obvious reasons, including in light of Brexit, wanting to do well in that process, there has been for some time now a significant focus on AML, and I think that's been perhaps complemented with some particular cases, enforcement actions, scandals in the popular press, which have presented this perception that London can be a hub for dirty money, and that, I think, concept is also being run with in some spheres to say kind of we need to do more in this area. And obviously there are views on the validity of that perception, but certainly there have been a number of AML cases with a London focus which have driven some of the activity that I think we're seeing.
It's not just London, is it? There have been banks going down in Latvia, Estonia, Malta.
Correct. So there's a real kind of flurry of cases across Europe focusing on lapses in AML controls, which has, I guess, piqued interest in this area. Also domestically, we've seen the use of the unexplained wealth order, which I think is a good thing, and we're starting to see those cases play out in the courts at the moment, which will give more colour on how the unexplained wealth orders can be used in the UK.
I think it's also important to understand the continuing influence of the US. So the Maltese bank in question and the Latvian bank, both of those were brought to arms by the US, and with the follow-on action at the EU level. So as is the case around sanctions, but now more so into AML under the Patriot Act, I think it's difficult to ignore the power of the US and their extraterritorial reach, and the need for the FCA, for example, to act accordingly.
Do you think the European Commission was embarrassed by the fact that it was the US who unearthed these problems?
I think who can speak for the European Commission, but I think having seen the issues with the two banks in question, someone's going to need to have been embarrassed.
Which I suppose brings us on nicely to what's being done about it. And what is being done about it is that the European Commission has launched a plan which is on the back of the ESAS review to give much greater powers to the European Banking Agency. How does the panel feel about that width of powers, and is it the right thing to do?
So my overall sentiment on this is that it's a positive move. with all of this noise in the AML environment, I think it's a good thing that we're seeing the ESAs take this seriously and also look to do something different than what has already been done. We've seen in the last 4 or 5 years the iterations of new money laundering directives, which every time has been positive insofar as taking action, responding to an event, and trying to turn the screw in the environment and make the framework tighter. What we haven't always seen is necessarily consistent oversight across the European countries. For example, certain banks in certain jurisdictions may be subject to a more light touch approach to regulation, or there is a different testing environment to how systems and controls are approached. And if the EBA is able to bring some harmonization to that, working with each of the countries to put in place these frameworks, I think we will have a positive outcome on the back of it.
I think I'd agree with all that. From the perspective of AFME, our members are, of course, banks, but they're also more, before they're banks, they're securities houses. And our membership is the sell side securities industry in Europe and not just the banking industry. And I slightly worry that the EBA's expertise is in banking and not in securities. So I think it would be important that ESMA is quite closely involved in this process.
I think it's not just are they qualified, but also are they equipped. I think it's important that they can't go in with thinking a head count of 3 people, not knowing if that is the head count, is going to be able to bring a unity across the EU. So I think there's a lot for them to think about. Personally, I was looking at the reasons. I mean, the original paper brought about prudential concerns versus AML. I'm not sure that the banks in question were quite the right topics for that. They seem to be set up with less than valid intent. Perfect example being ABLV in Latvia, which was highlighted as a bank of primary money laundering concern by the US, which basically sort of talks of things that they're in a fairly willing situation to accept and deal with criminal money. And you look at things that are closer to home, Danske, for example, whereby they've gone through a hard time at the moment, but there aren't any necessary prudential concerns being raised around their ability to continue to operate.
Yes, I think your 3 headcount might be optimistic. The EBA apparently had 1.8 persons working on AML headcount until recently. That presumably will now be increased. Moving on, I think, to data, your point about getting the data right. It's all very well having more headcount, and they do need more headcount. But isn't it the case that most suspicious activity reports actually don't result in action being taken?
I think that's one of the problems. We don't know. We know we file lots of them. We don't necessarily know where they end up or what happens with them. The UK files upwards of 400,000 in the last reporting year. As an MLRO, as a London branch of a bank, we certainly don't get any feedback on our SARS. So it's difficult to know if from the front line whether we're making a difference, whether what we file is of any use whatsoever.
So the number of suspicious activity reports filed in the UK last year was 363,000. And the number of internal SARS was 922,000. So about 2/3 are being weeded out at the internal level. But then 363,000 SARS, that is an awful lot of data going to the regulators. Do we think it's being well used, and do we think it can be better used to enable organizations like the ECB to then work out what enforcement action they should be taking?
So in the UK, the NCA do a great deal in publishing information, which I think should be applauded. To the extent where we're talking about that information coming back to banks, I think a common request from financial institutions, which I've heard at a number of meetings, is better typology and understanding what the NCA or other competent authorities are seeing, because we can be reactive to what they are seeing and do more targeted surveillance as a result. So at this moment in time, I think more could be done in sharing information with the financial sector. And I think we've seen in the UK a real push towards developing that public-private partnership through the joint money laundering intelligence group, which, for everything I'm hearing, it has been a good success and long may it continue.
And I think in the UK, plainly, we have a slightly unique creature in our consent regime, and we're also, I think, quite an outlier in terms of the number of SARs we report. And there are clearly issues to be looked at in terms of the legal framework within which the UK reports SARs, and perhaps we'll talk later about the Law Commission review, which it was hoped would precisely look at those sorts of issues. But sort of stepping back, one has to question sort of why, given the sort of overarching framework of 4MLD, there are such disparities between different countries to the extent the data is even available in relation to the numbers of SARs reported and the activity based on that. And I think, again, that must come back to both the supervisory aspect and the discrepancies that Rajiv was talking about, and also presumably differences in law enforcement use of the data that is reported. So I think certainly that in a sense the statistics talk for themselves in terms of saying that there are some issues there to be fixed, not only in the UK but also in other EU jurisdictions.
I think that's right. And you mentioned the fourth anti-money laundering directive and indeed the fifth. So there's lots of regulation out there. It isn't being well harmonized, perhaps. What specific issues do AFME members have with either the fourth or the fifth money laundering directives in terms of implementation?
So just to maybe give you some feedback I've heard from a number of our working group meetings, the timeline for transposition at a domestic level has been slightly off. And it didn't meet the, I think it was 24th of June 2017 deadline. And a delayed or a staggered approach to this makes implementation for international institutions with a number of different offices or operating in a number of different EU countries problematic. As it's a directive, each of the countries has some flexibility in how that is transposed domestically, which also results in nuances, which creates challenges for implementation also.
I think the general rush, I think, is a fair word around its introduction. Get a lack of real time to consider what was being proposed and to feed back on that has led to elements of gold plating, which from a UK perspective mean that there's certain things we're doing that are above and beyond the requirements of 4MLD, which is difficult from a competition perspective. How do we remain competitive throughout Europe if, as a UK company, we're actually being asked to do more from an AML perspective than people that operate within France or Germany, for example?
I think the regulatory answer to that would be that you're in a better position in the UK because the rules are tougher. I'm not sure that all the practitioners would see it that way.
And I think, hopefully, perhaps there'll be some lessons learned from 4MLD implementation when we come to 5MLD implementation in relation to the timeliness of consultation, availability of the draft regulations, etc. And clearly the government has indicated to date that the intention is still to implement, notwithstanding Brexit. And I think it is worth noting that the fifth directive isn't quite the same level of wholesale changes we saw with the fourth. There are some aspects of business, for example, crypto exchanges being brought into the regulated sector for the first time, but for members here for credit and financial institutions who are already in, there are some potentially significant changes around things like enhanced due diligence, which will, I think, need some careful working through and some time to think about, but it's not the same level of kind of across the board tweaks or more substantial changes that we saw with the fourth directive. So I suppose there's that shred of comfort, although nonetheless clearly important to have sufficient time to consider and implement.
The ultimate benefit ownership rules, will they help?
Do you mean the US rules? Or the
registers?
the UBO registers?
Yes.
I have to say I'm quite sceptical about the whole thing. I mean, one of the things that actually I won't say outraged, but on one view, one could say one's a bit outraged on principle about in the fifth directive, is that at the moment you've got the requirement to have the corporate UBO registers, which member states have to maintain. What you see in the fifth directive is a requirement for firms when they're onboarding customers not only to check that, but to report on any discrepancies which they identify. So they effectively become the policeman of the register, which member states are otherwise not devoting the resources to. And you may be aware the one known case to date of an individual being prosecuted for providing false information to Companies House under the PSC register was a chap who set up a company called Cleverly Clogs Limited and Cleverly Clogs Limited and registered various members of Parliament, including Simon Cleverly, who I think at the time was the Minister for Business, as its sort of PSCs. And then wrote to them to say, did you know your system is rubbish? Because anyone can register a company and put your information on it. And he was promptly prosecuted for his pains as a transparency campaigner. So I think it does underline there are some issues with the effectiveness of the current system, notwithstanding its, I think, good intentions. Whether we fix that by imposing additional burdens on the private sector, it seems to me is not the ideal way forward, but it's the way we seem to be going under the fifth directive. And that's also going to beef up requirements in relation to trust registers, which will become quite a lot more extensive.
So the only individual who's being prosecuted was an investigative journalist trying to point out how the system wasn't working.
A transparency campaigner, reportedly, yes.
There's a lesson there somewhere. You mentioned earlier the difficulty in harmonisation, and it's not just, of course, across Europe there is harmonisation difficulties, but worldwide. And we've recently seen the FATF, as they like to call themselves, not FATF, I was told when I went to one of their meetings and used the wrong term, published a document called the Risk-Based Approach Guidance to the Securities Sector. This is a very long document which came out about a month ago and attempts to give guidance to the securities sector on AML matters, basically. How has this gone down with the industry and the legal profession?
I hesitate to speak for the legal profession. I'm not sure how many people have read the whole thing. I will say I have. I think it's broadly helpful. I think it's, again, well-intentioned. I think the difficulty is trying to be all things to all people, and the securities sector is a very large and diverse sector, particularly as it has been defined for the purposes of this guidance document. So I think one of the challenges is providing kind of useful granular guidance that covers businesses of so many different types. Having said that, there are pieces in the guidance which I think provide helpful ideas on risk assessment, on steps that could be taken from an EDD or SDD perspective. So I think it's certainly, from my perspective, worth reviewing, but probably not groundbreaking, I would suggest, particularly for people in the UK who have a fair amount of guidance in the sort of JMLSG and other guidance documents already.
Well, now that you've given your views, Susannah, I can declare my interest, which was I was part of the drafting team. It was very interesting when we did the work on this. The drafting team consisted of a bunch of private sector individuals, such as myself, and public sector individuals, such as representatives of the SEC, other regulators. And the instructive thing for me was how different the views are in particularly the States as against Europe. We've heard how there's lack of harmonization across Europe. In the States, everything is very rule-based, very little principles-based, and quite often a proposal would be put in the drafting process and somebody will say, well, that didn't work, it doesn't work in the States. So a counter proposal will come and we say, well, doesn't really work in Europe. So the document is high level. That said, I think a couple of positives I take out of it. One is it is there, it does exist, and it does provide some useful guidance, albeit not granular. The second thing is it was a lesson to me about how well the public and private sector can work together. And at the end of it, the 8 of us who had been on this drafting committee knew each other very well. We still stay in touch. And I sort of feel that the more that the public sector and the private sector can collaborate on this and any regulatory subject, the better. And I think Rajiv, who gave the example of Gimlet in the UK as something which does a good job in this space. I think the message that perhaps we need to get across to FATF is please do more of these things, but they don't need to be very granular or specific. Unlike perhaps getting to the next topic, the JLMSG guidelines, which are pretty granular and have a very specific position under English law, which as far as I'm aware, no other non-public sector document has, which is that if you comply with them, you have a safe harbor against a prosecution or enforcement action in the AML space. Have I got that right, Susannah?
Well, the court needs to take it into account, so sort of in effect, yeah.
And what is the view again from the legal profession about the JLMSG guidelines as they currently stand?
Look, I think it's an enormously helpful document and has not only the particular legal status you've referred to, but also the sort of weight of many years of use behind it. And of course, irrespective of the court's requirement to take it into account in any prosecution under the regs, the FCA, of course, always considers it in its enforcement actions in the AML space. So I think it's a really important and in many ways very useful document. I think some of the recent revisions to Part 2, some of the sectoral guidance in particular, I think has again been very helpful. I think there probably is some more work to be done on Part 1 and probably in view of the compressed timetable for implementation of 4MLD, the changes made to reflect that were relatively limited, and I think there needs to be some more substantive redrafting, in particular of the stuff around simplified due diligence, but also in a few other places, to make sure that it's the most useful tool that it can be in guiding firms in compliance with their regulatory obligations.
It's Part 1 that needs to be worked on.
Yes, I think as a priority, there are also some bits of Part 2, and you've already mentioned the AFME work on Chapter 20, for example. But it seems to me for the main run of firms who will be looking at this on a very frequent basis, there are some priority bits, in particular the CDD chapter of Part 1 that needs looking at.
Agreed. I think also the growing level of guidance being issued by government bodies. So, for example, OFSI have recently issued their sanctions guidance. Part 3, JMLSG also caters for sanctions guidance. So is there a need for both to talk about the same thing? And if so, how do we ensure consistency?
What about the work that AFME's been doing on Part 2, Rajiv? I think you're on the editorial committee.
Yeah, and I think AFME's demonstrated its use in helping to draft a number of sections which really impact the wholesale markets, and it's been beneficial being part of the group to that end. Just on the kind of breakout of JMLSG, there's often been a debate about what role does JMLSG play in interacting with other government publications. John, you mentioned the OFSI guidance, but also the FCA Financial Crime Guide, and the two are very separate, and it's about providing a framework or the flesh to the money laundering bones, the money laundering reg bones, and we kind of add on top of it and provide the guidance on how you can interpret specific parts. the FCA guide and more bespoke government guidance is very specific to the kind of points they want to communicate out. So the two will often play different roles, and you should be reading them or looking at them in combination. But if you read one, you're going to be missing something from the other.
I'm actually on the board of the JLOSG, and we make quite a lot of effort to go out to our constituents and say, what do you want from the JLOSG that is different from what we're doing at the moment? I have to say we don't get an awful lot of response. So if there are any members on this call who would like to tell the JLOSG how to do things differently, we'd like to hear that. I think the consistent one we always get is the guidance is very difficult to search. It just exists there. I think if it's not a PDF document, it's very like a PDF document, and it's very difficult to find your way around it. That is being addressed, and the JLOSG is in the process of improving or indeed instituting a decent search technology which will help. Other points, I think I've heard it variously that it's quite complex. Well, unfortunately, this is a complex subject. But it's very granular. Unfortunately, this is a granular subject. But I've never heard anybody actually say to us we should discontinue JLOSG, and I think I can see eyebrows going around up in the room as I say that. It seems to me that it's something that is well worth having, and I know that it is being copied by other jurisdictions around Europe at the moment. Certainly, the Swedes and the Danes.
South Africa. We're a South African bank, obviously. It's often found on the desks of financial crime people in Johannesburg. I think it's given more credit globally than it is. I think we've almost become quite used to it and critical of it. But globally, it gets a hell of a lot of credit because we take for granted the fact that we have guidance. A lot of countries have their regs and that's it.
And I mean, indeed, in other sectors. So I mean, I'm on the committee which is partly responsible for the legal sector guidance to the legal profession in the UK, and therefore I cannot and should not say anything disparaging about that guidance, which of course is very helpful. Nonetheless, I think you would not find it unknown in many law firms around the country for people also to be looking at the JLOSG guidance for additional granularity in some particular areas which are also relevant to the profession. So I completely agree with that. I think it's an important document, and my eyebrows were certainly among those which were raised when you said, Will, that there would be any consideration of getting rid of it.
I think it's probably a victim of its own success as well. So we've gone through 4 MLD, and obviously it was rushed through, and there was little time for consolidation and review and consultation. But on the back of that, it's in existence now, and people know and love it or hate it. Whereas you've got the Criminal Finances Act, and then you know the number of other regs that are coming through at the same time, which probably because they're new, get the business or the industry focuses on more than putting any help back into the trade bodies who are writing the JLOSG.
Don't get me wrong, I'm not in any sense proposing that we should do anything with JLOSG. I'm just saying that it, like any organisation, has to look at its raison d'etre and its budget on an annual basis and make sure that it's delivering what its members want it to do. And AFME is approximately 15% shareholder in JLOSG. But we're slightly straying from the subject, which is a new regulatory framework. And the Law Commission has just put out a consultation on AML. 700 pages, was it, or something like that? I confess I didn't read every line, but I know Susannah did, so perhaps you'd like to talk us through it.
I've not read every line. I've done 3 consultation responses, so I feel I've lived with it a little bit now. So this is, on the one hand, an important consultation, and in the other, perhaps something of a missed opportunity, because this could have been a sort of once-in-a-lifetime opportunity to have a really fresh look at SAR reporting in the UK. So this consultation is focused on Part 7 of the Proceeds of Crime Act, which deals with what the money laundering offences are and the consent regime, the failure to report regime, and to a much lesser degree, there's some mention of tipping off. So although the consultation asks some open questions around has anyone got any good ideas as an alternative for consent, broadly speaking, that most of what the consultation is devoted to is a more a sort of less drastic change, which is looking at the reporting threshold and whether we should move from suspicion to a sort of suspicion on reasonable grounds sort of a test. Now that is controversial, and I think many industry participants actually aren't keen on that proposed change, but that's a central thrust of what they suggest to try and reduce the number of what are seen as low value SARs. Having said that, within the, as you say, very long consultation, there are actually some other ideas which are, again, not big overhauls, but I think could be really useful if implemented. And those include, for example, Chapter 10 of the consultation, which deals with fungibility, issues around mixed criminal funds with clean funds, and the circumstances in which you then need consent. And also some proposals via guidance to reduce low value reporting in cases, for example, where you're sort of duplicate reporting to different agencies, or reporting information in the public domain, and a range of other sort of known scenarios where the legislation would require a report, but the perception is that it's not a good use of firms' resources, or indeed of the NCAs, in dealing with those matters. So the consultation period closed a couple of weeks ago, I think, and so we're waiting for the Law Commission to review those responses and bring forward any proposals. As I say, I think there's still a need for a further look at the regime as a whole, but there may at least be some improvements, perhaps more around the edges of the regime coming out of that. And separately, there's an ongoing process looking at sort of SARS reform in terms of the build of the system into which people are reporting SARS, and that's a sort of parallel process with a significant IT element also.
What's the timing for all this?
Well, it's an interesting question, and query how Brexit is going to impact it, not from a requiring any changes to these reforms, but more just on a sort of resourcing and parliamentary time kind of perspective. I mean, so I would be surprised to see very much happening before perhaps the middle of next year, but that is speculative rather than based on actual information.
But consent is going to stay in some shape or form?
Yes. So as I say, there's one of the questions in the consultation is, do you have any brilliant alternative suggestions? But given that this has been in various roundtable consultation actually for a year or two now, and no one has come up with an alternative which seems to satisfy all stakeholders. And so for now, I think consent remains. What we probably need is a bold suggestion at some stage to say this is the alternative, but that needs to be based on perhaps again some prior thinking around what the objectives we're actually trying to achieve through the SARS programme is, and how those objectives weigh against the burden to the private sector of the resources invested in the current system. And those sorts of data points, I think, need to be pulled out again in a sort of used as an evidential base for some further more fundamental proposals for reform.
So we've got the UK doing its own review at the same time as we've got the EU doing its own review, and we've got Brexit in the mix. So it's going to be an interesting period of time. We'll come to Brexit later maybe, but one of the topics that is on slide 5, which I jumped over, is the FCA's thematic review of money laundering risk in the capital markets. This is a review the FCA announced recently where they're going to visit a number of firms and specifically are interested in the ability of the capital markets to provide a vehicle for money laundering, be it layering, integration, placement, or whatever. Have any of our, not asking you if you've been visited by the FCA, but have you any thoughts as to what the FCA might find in this space?
I think it's important to point out that the high risk rating in the UK National Risk Assessment is based on knowledge gaps as opposed to actual knowledge that there is inherent weaknesses in the capital markets within the UK. So the thematic review, from my understanding, is 3/4 fact find, but there's a quarter element that if they think or see that you're doing something wrong, they will act anyway. But I think that's an important principle here, is that it's trying to put some meat on those regulatory bones again, that we had a bank a year or so ago that was found to have aided or abetted money laundering through the capital markets. That's raised some alarms. It was then realised there was knowledge gaps. We've got a high risk rating in the UK National Risk Assessment, and we've now got the FCA taking a roadshow, for want of better words, to try and better understand where those risks may apply. We've also got a working body at GIMLIT, which AFME is a member of, that's also looking at money laundering through markets. So there's a big piece of work ongoing here to understand whether or not we have an issue, not yes, we've got an issue, how bad it is.
So I think the FCA should be congratulated for actually taking the lead in trying to understand more and put together, through a piece of work, more knowledge on how this all operates. And also, given that FATF have been doing more work in this area, given the risk-based approach for the securities sector, you're seeing that there is an international and domestic element to understanding this sector in more detail. From many of our industry meetings and also our rewrite of the wholesale markets, I think a starting point is just how the markets work, and that the market players may not see the entire picture of a particular client, and that actually inhibits and limits the ability of what an institution is able to surveil and report. So I think once the kind of puzzle is all put together and the authorities understand it in better detail, we can perhaps come out of it with more risk-based guidance from them for how they want to supervise and look at the industry and the risks and how they're managed.
Yeah, I'd agree with that. Certainly also there's a point that the FCA doesn't get SARs, they go to the NCA, the FCA gets stores, some of which also go to the NCA in the form of SARs, so they're not seeing the complete picture either, but certainly the sell-side banks that AFME represents are only seeing one side of the transaction. May be different from entities such as custody banks. They might see a bit more, but I would agree with Rajiv. It's great that the FCA appears to be going out and saying, okay, we don't have the knowledge base, so let's go and get it, rather than doing what happened in the National Risk Assessment 20 months ago, when they just said the capital markets are high risk, and there was no basis that I'm aware of for that statement. So I think we can see this as a positive, but I would also echo what John said, which is that if a regulator goes in on a thematic fact-finding exercise and finds lots of facts that it doesn't approve of, it will inevitably follow that with an enforcement action. So that's just, I'm afraid, life. And lastly on this slide, we have another few matters not on the slide. The FCA published today its financial crime data, and I don't suppose anybody's had a chance to read it. It's a 16-page document which I would commend to you. The most interesting thing in it that I found is at the back of it, the FCA has published a conglomerate assessment of firms' view of country risks. Now, this has to be distinguished from the document they published a few years ago briefly and then unpublished, which was their list of high-risk jurisdictions. This has taken the answers that firms are given as to what jurisdictions firms think are high risk, and has put them together in a table where the top of the pops is Iran, followed by Panama and Russia, and the bottom, not surprisingly, are Norway and Sweden. Slightly surprisingly, the least risky is the USA. But I do commend that to people because it's an example of the FCA actually having gone out and got a lot of information and published it. And there may be some that they haven't published, but what they have published is worth reading. We are at the end of the sort of formal part of the presentation, and we now are pushing this out for Q&As, and if you have forgotten, you can submit questions for the Q&A at any time, and specifically now, please, by clicking on the Q&A icon on the right-hand side of the screen and typing in your question. Your name won't be used unless you ask it to be used. And the first question says, as we all seem to agree that better information sharing from public authorities to FIs would improve effectiveness of the AML framework, the EC proposals seem to miss out on the opportunity to tackle this. It rather adds even an extra layer of supervision via the direct powers to the EBA. What's the panel's views on this?
I agree, it's adding another level of supervision. We have to ask the question, at what point is consistency of approach likely? Do we keep building the supervisory layer? From an information sharing perspective, it's yet to be seen how that's going to work across the EU. We've proved it can work in the UK with GIMLIT, and that seems to be working very well. I'm not hearing or seeing anything that would suggest a similar type of approach on the continent.
I would certainly agree that it is an extra layer of supervision, whatever. The question is it an effective layer of supervision? You could say the current system isn't working very well, anything is better, but you wouldn't say that if you were one of the banks who were faced with having to now to produce more and more data and send to more and more different places, if you didn't think it was also going to result in more effective law enforcement.
So I got the impression that this is more supervision for the competent authorities domestically and less about the financial institutions. So we will still be answerable to our competent authority domestically, but there will be better supervision of the domestic authorities. Just to the specific question about information sharing, one would hope that as time progresses, the European authorities will have more information and will push more out, giving a consolidated view. But I think domestically more work needs to be done on the domestic interpretation of how they want to info share. I think that from a UK perspective, we're getting somewhere, and we've seen inroads into this area, with GIMLIT being a fantastic example. And we will see hopefully more development in this area.
And I think the only thing that I would add, which again isn't so much on it doesn't really touch on the public-private information sharing again, is just to note that I think, as Adam mentioned at the outset, what we're looking at is not just the EBA proposals, but also the more recent, and this is the 8th of November consultation paper on cooperation between competent authorities. So this is the ESA's paper looking at the establishment of colleges of competent authorities where financial or credit institutions are operating in sort of 3 or more jurisdictions, which again seems laudable in purpose, but does potentially add quite a lot of additional sort of bureaucracy in terms of supervision. And actually, one of the specific concerns that's expressed is that competent authorities who receive information in that as part of their cooperation in the college shouldn't be free without consent to sort of share that more broadly, because that could impede the confidential nature of those communications. So I think, again, another layer of supervisory cooperation and potential consistency, but certainly no indication anywhere in that paper, although admittedly it's not what it's directed at, that there would be any greater sort of feedback to individual institutions.
So that, I think, brings us to the next question, which is the B question. How is Brexit going to impact all this? We've discussed not great harmonisation across Europe. We've discussed what they're proposing to do about it, albeit in fairly high-level terms at the moment, but focusing on the EBA. We've discussed what the Law Commission has in mind. We've got our own ideas as to what might happen. But what is the specific immediate Brexit input. Susannah, I think the SI came out today.
Just 2 hours ago, so we are terribly topical in this webinar. Yes, so the money laundering regulations, of course, are made under the European Communities Act, and so they are part of the sort of body of law that gets kind of grandfathered across under the EU Withdrawal Act. And the statutory instrument that's been published today makes changes to the money laundering regs to sort of remove specific EU references which kind of don't work anymore post-Brexit. So things like requirements to comply with the ESA's guidelines and other sort of specific references of that sort. But it's not, it is quite, they are small changes by way of amendment to the regulation rather than an overhaul. We do have the Sanctions and Anti-Money Laundering Act as well, which is actually the first piece of primary legislation passed to facilitate Brexit, and that will enable sanctions instruments and sort of replacement money laundering regulations to be made under it. And the concept there was that the UK would need to be able to be nimble to respond, for example, to changes in sanctions regimes or to adapt the money laundering regs to reflect further risks. So that is just an enabling statute. It doesn't tell us anything about the detail of what the regimes will be. So strong expectation on the money laundering front, particularly given our regime is derived from FATF standards anyway, and we will want to be equivalent to the EU, that there will be very little change post-Brexit, particularly immediately post-Brexit. Over time, potential for further divergence, I would say, particularly in relation to sanctions, but perhaps that's a topic for another day.
And presumably the ESA's guidance that exists in the money laundering space will somehow be transposed into UK law?
Well, at the moment, there's a sort of summary of part of it in the JMLSG guidance, actually, so query whether that sort of remains or how that's addressed. It's some of their guidance on simplified due diligence is now an annex to the main chapter on CDD in part 1. So I would have thought there would be some desire to still be able to have regard to that, query whether people will want to be bound by it in the same way. And certainly, I think under the statutory instrument as proposed, I think that will, I think the requirement to comply will move, although I must confess I haven't had an enormous amount of time to review it in the last 2 hours.
But I think it's pretty well known that the UK government and the FCA has said that on B Day we will be equivalent,
yeah,
whatever that means. And so therefore the AML law in the UK next 30th of March will be the same as it was on the 28th of March.
Yeah.
And you've got to go on doing everything you were doing until such time as something changes.
Absolutely. And I think it must be in financial institutions' interests here to be equivalent, not least so that we can be subject to simplified due diligence when being KYC'd by other firms within the EU. So I really don't see a big change on money laundering in any shape or form. As I say, I think the more interesting thing from a financial crime perspective is actually the future of the sanctions regimes.
And the reason for that is that the UK might go a more US-focused sanctions regime compared with continental Europe, or am I wrong about that?
Yeah, so there's a couple of things. So there's some changes of detail which may be sort of significant in practice. So, for example, greater scope for OFSI to give guidance on interpretation, broader licensing powers, possibly a different and clearer approach on ownership and control are all things which could flow from the UK having a bit more autonomy over these measures. In terms of the substance of the sanctions regimes, again, the UK has said that in the near term post-Brexit, they intend to simply replicate what's in the EU. But I think a concern, as you say, Will, both that the UK might, for its own policy reasons, want to forge a bit of its own path. And certainly there were some comments by the former Foreign Secretary as the bill was passed, the Sanctions and Anti-Money Laundering Bill now Act, that in response to the Salisbury incident, for example, this, post-Brexit would give us greater ability to impose sanctions where we thought appropriate, for example, on human rights grounds. So might we do more? And conversely, if the UK leaves the EU, might they do less, in the sense that the UK is quite a vocal voice in the European committees that are considering and formulating sanctions? So having lost that voice, is there a possibility that some of those sanctions might roll back in due course?
It's a good point. Applies across the compliance spectrum. The UK has been a very big mover within ESMA. That position seems to be being ceded to the AMF and maybe other NCAs, but obviously the FCA won't be there anymore. Final question for our two practitioners. This all seems to be quite a lot of work for you guys. And you're both smiling as though you're going to absorb that, no problem. But actually, it is a lot of work over the next year or two, isn't it?
It's been a lot of work for the last 2 years. So, I mean, it's not getting any better, but touch wood, it's not going to get any worse.
I think there's been an unprecedented demand for change in the last 2 years. And hopefully that will even out a little bit. For MLD across Europe. Then domestically, we've had the Criminal Finances Act. We've now got Brexit. All of these are high resource demand requirements, and hopefully there will be some lighting in the tunnel.
Okay, well, there are no more questions on the screen, so I think it remains for me to thank the panelists for giving us the benefit of your considerable expertise, John Clarke, Susannah Cogman, and Rajiv Kapur. Thank the members, of which we had a large number, actually 38 on this call. And if any of you aren't members of the AFME Financial Crime Working Group, some of you won't because it doesn't have 38 members, we welcome you on to that. I'd like to thank the AFME team, my producers, Marie Hempler and Claire Sweeney, and we will see you all again at the next episode of AFME webcast. So I'm afraid I don't know what the next subject is, and neither do my producers. So we're not that joined up, but thank you very much, and we will see you then. Bye-bye.